of the Birmingham Bar Association, Judge Coogler, the presiding judge for the Northern District of Alabama, has graciously agreed to participate in this video, providing an update on the current status of proceedings in the Northern District of Alabama. Judge, thank you for doing this today for us.
Thank you for including us.
Judge, I'd like to get your feedback and input and for you to provide some information to the federal practitioner and other members of the Birmingham Bar Association. If we just touch upon three subjects today, that would be greatly appreciated. What I'd like to talk with you today about is, first of all, the current status of proceedings in the Northern District of Alabama. Secondly, just your general observations, as well as your understanding of the other judges' handling of civil hearings in the Northern District of Alabama. And then finally, we greatly appreciate your input, thoughts, and comments on what you anticipate both with regard to criminal and civil jury trials over the next 6 to 12 months, especially in light of your participation as one of the few United States district judges on the coronavirus task force response team for the United States court. So, Judge, first, if you would mind just giving us kind of a current status on the proceedings in the Northern District of Alabama. I know that Your Honor first issued the March 17th general order that's set in place certain provisions as far as staying deadlines, canceling jury trials alike, and then there have been a waterfall of orders that Your Honor has issued based upon the change in circumstances.
Sir, when we first got into the situation with regard to the coronavirus, we felt like we needed to enable the judges and the lawyers also to not have to worry about deadlines, because they frankly might not be able to travel and do discovery and respond. And so we entered the first order, the general order, and it was designed to stay pretty much everything: jury trials, non-jury trials, civil, and criminal. It also was designed to stay the passage of the discovery and briefing deadlines that might be out there. And we felt like the best way to do that is one order, and that's where the March 17th order came in. And we entered that, and then that was good for 14 days because we, like most of the people in the country, really did not know for sure what we were dealing with regard to the coronavirus or how long it would be affecting us dramatically. We followed up after that on the with the general order with regard to criminal proceedings, and that was entered on the 30th day of March. And in that particular proceedings order, it allowed for, and it was an order that was enabled by legislation passed by the United States Congress and signed into law by the president, that enabled us to do video hearings in criminal cases with the defendant's consent. And so the Northern District of Alabama had already been experimenting with that actually since last summer, where we were trying to take situations where we had defendants that were in custody and we could do simple hearings, maybe a quick bond hearing so that we could get them out of custody and into a drug treatment facility. So we already had in place in 2 of our jails computers that had the ability to do these teleconference hearings. And so it was not very difficult for our staff to then move forward with putting computers in the other 7 facilities. We have 9 facilities that hold prisoners for us. So we did that. And we also with the assistance of the IT department in our court, turned on a public access channel, if you will, where individuals who want to watch the criminal trials or even the civil hearings or trials could simply email a help desk, and they would get a link that they could click on, and they could sit and watch from anywhere they were the criminal hearings. And that's unusual. Normally, we do not permit broadcasting of any federal court proceeding, but we had to do that because we needed to make sure that the courts were open to the public. We then followed it up with a second order, and this one was entered on April 13th, our third order, but a second order dealing strictly with the civil aspects. So on April 13th, we stayed the civil deadlines, discovery deadlines, briefing deadlines, and whatnot for another approximately 14 or so days, another 2 weeks, and set them to expire on April 30th. The concept, and then we ultimately allowed that to expire on April 30th. The idea, and with regard to all of these orders, we were encouraging the attorneys and parties to talk to each other, and if they could safely conduct discovery and briefing and that type thing, then we were encouraging them to do that, to continue the process. Because we know that a lot of firms, a lot of lawyers were teleworking and were continuing their business. The court system was also teleworking. We didn't shut down at all. As a matter of fact, my criminal docket, and I can just speak for myself, has moved just as quickly as it ever has because we've been doing things by video conference. And I think that's true for most of the rest of the judges as well. And civil hearings, the things that slowed them down were not the court's availability, but the fact that you all as attorneys may not have been able to get the discovery or briefing done to submit to us. So there was a 45-day window, roughly 45 days, where all the deadlines were stayed. Once we canceled the stay on April 30th, we then are starting the process, all the judges, and they're doing it however they choose to do it. My court, my cases, we're actually sending out orders in cases and getting the parties to tell us, did they continue doing discovery? Do they believe they want a shorter period of time? Do they want the entire 45 days? Tacked on to the end of unexpired deadlines? It doesn't affect any deadlines that expired before March 17th. And we're getting responses back. Some of the attorneys are saying, we continued on just like regular and we want to keep the case going. And some lawyers are going to the other extreme and saying, we need a little bit extra time because even though you gave us 45 days, some of the discovery we have to do is located in areas of the country that are basically still shut down. So we're adjusting those, resetting deadlines, and getting the cases moving again. As part of the original order on March 17th, we continued all jury trials, criminal and civil, grand jury proceedings, and civil proceedings or any other hearing that would have actually occurred in the courthouse. Then we're in the process of opening all that up now. We started with civil and criminal hearings. On May the 4th, we entered an order, which is the general order number 7 for 2020. And it specifically said that the prohibition on conducting hearings, in-person hearings in the buildings is eliminated. But each judge is encouraged to continue as much as possible to do teleconference, video conference hearings. And we wanted to make sure that every judge could discuss the matters with the attorneys they had in cases and with the advice of the attorneys and considering the specific case information, the parties that were involved, the witnesses that were involved, where people were having to come from, all of that information could decide if an in-person hearing was appropriate or not. And if it was not appropriate, then then of course the hearing could either be continued, delayed, or there could be a video conference type hearing that was conducted. I, for one, have held many teleconference hearings long before coronavirus was a thing, and I'm still doing that. We now also have a lot more video conferences going on. Ordinarily, some of those would actually have been done by teleconference before, and people want to see each other, so now it's video conference. But either way, it's moving right along. You also asked me about juries, and when you're ready, I'll talk about that.
Thank you, Your Honor. You actually did touch upon the second topic, was basically the status of civil and criminal hearings before the court in person. And thank you for reminding us or pointing out that on May 4th, Your Honor entered that order that ended the prohibition on in-person hearings. So what I hear you to say is that it's going to depend upon the nature of the matter, the parties, and some other factors as to whether or not there'll be an in-person hearing, or perhaps it might be just as effective for right now to continue with telephonic or video hearings.
Absolutely. And, sometimes there's this misconception that a chief district judge is the one who makes all these decisions, but I assure you that is not the case. Chief district judge is just one of the group, and I am appointed to speak for the group. I listen to what the group wants. We consider all the issues. We actually vote on the issues. And so all of these orders were talked about, considered by the entire court, and it was the court's action to enter them. But with that said, every one of them has tried to consider leaving the ultimate decision to the individual judges. For instance, in the orders that said that everything was stayed for 45 days, all the deadlines, it nonetheless left it up to the district judges or the magistrate judges. If they had a case that there were unique circumstances that necessitated a change in that, then that judge could follow their discretion and make that change. And the same thing now with the in-person hearings. While most judges, I suspect, will continue to do the teleconference, video conference methods for now, there's nothing to prohibit that judge from actually having in-person hearings if they want to. I will say this: if you're going to have an in-person hearing, civil or criminal, then you as an attorney need to make sure the judge is aware of all the factors that would educate that decision. Like when you have lawyers that have risk factors, or parties or witnesses that may have risk factors that judge needs to be aware of before having that hearing. So if a judge sets a hearing and for instance, that someone involved or that needs to be there has risk factors, then you need to request a teleconference with the judge and explain that to the judge so that we can all make good decisions. Nobody on the court wants anybody to be at risk. We want to just do our job and try to give you all the tools that you need to accomplish yours.
Judge, thank you very much. That's very helpful. And let's turn to this last topic about jury trials. And I think you're probably one of the most informed U.S. District Court judges, given your participation on the coronavirus task force. And you just kind of share with us your thoughts and expectations as far as criminal and civil jury trials in the next 6 to 12 months. And there was an interesting article in today's Wall Street Journal about, I think, a district court judge in Montana that was undertaking to schedule a jury trial, I think in a middle school gymnasium. So if you can kind of share with us what your expectations, that would be helpful.
Absolutely. I'm actually on the subgroup as well, doing coming up with the guidance, if you will, that's going to be passed out to the courts throughout the country and standing up the jury trials, as they call it. And the one thing that I will say is that all the different places in the country will have different decisions made by their judges as to when the right time is to not only start jury trials, but also the method in which to conduct them. And civil and criminal jury trials are going to be different. In the federal system, as you all know, we only have to have 6 jurors to make a decision in a civil case. We have to have 12 in criminal. Also, that when you reduce that down, and maybe we end up with 8 jurors typically in a civil case, so that 2 are expendable, if you will. We have a lot less individuals we bring in for the venire, so that we can make a decision of who's going to be on the juries for the voir dire. And in criminal cases, there's a lot more individuals that we have to bring in. And that is the most difficult part of selecting a jury. When you're going to bring in, say, 40 individuals to pick a jury, a criminal jury, for instance, then you have to figure out, where am I going to put those individuals so that they're socially distanced to make sure that they're safe? Well, we're looking at that. We're looking at that on a national level, and we're looking at it on a district level as well. Right now, we are going to be impaneling a grand jury in the middle of June. And that will be the first jury event, if you will, that we're actually going to bring in individuals who might be picked to be jurors. We already have a grand jury that's meeting, but it's only the grand jurors that are on that grand jury. So we're able to communicate with them and make sure that they have personal protective equipment and make sure that they're socially distanced. What we're doing with regard to this grand jury is we're actually sending out a questionnaire. It's a link to a digital page on the internet, as well as a mailed questionnaire, so that if an individual does not have access to internet where they can go through and just mark information, specifically what we're trying to get at is, do you have one of the risk factors? Do you live with someone with a risk factor? Have you been exposed to the virus? Are you a caregiver? Are you a first line of defense in the medical community, or are you a first responder type individual? We're trying to be sensitive about all those things so that we can, if you will, pre-screen certain individuals that maybe are more at risk than others, because we don't want to endanger their lives. And we have to do this carefully, because we cannot afford to upset the balance of the jury makeup. Everyone has a right to have a jury of their peers, and it's a cross-section of society. And if we only pick the individuals that have an iPad, for instance, or something in their hand, and they can really quickly manipulate it, then people like me, maybe that are 60 years old, may not be the best person to do that, and I might get screened out. So we have to be considerate of that, and we're looking at how do we do that. With regard to civil juries, when we start bringing in civil juries, and I suspect that'll be the middle of July for our district. That's just a guess now. We're keeping our finger on the pulse of the area and trying to make a decision. And we may move a little quicker, we may move a little slower. But with regard to civil juries, if the attorneys can work out with the court a method by which those jurors can actually be voir dired online, much like you and I are doing here today,
right?
Then if we could set up, even if we have to send a loaner iPad with a MiFi card to different individuals' residences, then we could accomplish only bringing in the jurors that are actually picked to be on the jury. We wouldn't have to bring in 30 to get down to 8. We could bring in 8 individuals. Mm-hmm. And we could give them the personal protective equipment before they even show up at the building. We could space them by social distancing and alleviate much of their concerns. There's one thing for sure, it doesn't matter. We cannot absolutely guarantee anyone's personal safety. You could get the flu when you're doing jury service. You could get anything, and we're going to try to do the best we can to make sure that the risk is limited. When we go to criminal is going to be much more difficult, because I don't know why we probably will be able to accomplish the pre-screening. We'll have to start with a much bigger number to do the pre-screening to get down to the others. But then we're going to probably have to bring those jurors in panels where we have a certain number, maybe it's 8 or 10 that report at 9 o'clock, and we have 8 or 10 that report at 11 o'clock, and we do many voir dires for those individuals. Maybe we even do a little bit more with regard to questionnaires before they ever even get to the building. The problem with questionnaires is we don't get, when you do questionnaires, you may get the jurors' answers, you may get their cousins' answers or the parents or somebody else's answers, and you don't know. And so that's always a concern that we have. But regardless, we're in the process of developing that. Throughout for a national level on the big picture, because I know some of the federal bar members also practice in other districts. Some districts have a lot more problems, both with coronavirus cases and deaths than we do, fortunately, down here. They also have issues with public transportation. A lot of their individuals that come to work every day in the big city come by public transportation, subways, trains, and that seems to be a big risk factor as well for those individuals.
Right.
So there, as a court system, we're trying to figure out how do we deal with that. And so probably what you're going to see is a lot of those districts will start their jury trials much later than we would in the areas like in Alabama and whatnot. I think we'll move a lot quicker than other parts of the country. They will nonetheless be watching what we do. When we have jurors, I would suspect that you will notice that the lawyers will be limited to talking from the podium. There won't be any documents that will be passed to jurors. They'll simply have to use the Elmo, that type thing. When the jury deliberates, they'll probably be deliberating in the courtroom as opposed to a jury room. We'll probably excuse everybody out of the courtroom and let the jurors have their breaks in the courtroom as opposed to in the jury room. We'll do little things like that make sense. We'll be doing a lot more cleaning of the areas that the public touches. But with that said, I think the best defense for anybody to the virus, whether they're in one of our facilities or they're at the grocery store, is to just assume that the virus is wherever they're going to touch. And they need to clean their hands. They need to use hand sanitizer or wash their hands as recommended by the CDC. If they are out in the public and cannot social distance, is my understanding what the CDC is recommending, that if you cannot properly social distance, you should wear a mask. And that's not necessarily to protect yourself from somebody else, but you could be asymptomatic and have the virus and be spreading it.
Absolutely.
So, right. So having a mask on when you might encounter somebody with a close distance always makes that kind of sense. So we're going to try to look at all of that. The one thing I can assure you is that we are going to be looking to the attorneys and getting advice from them, recommendations from them. I could not imagine, for instance, trying a criminal case or a civil case without talking to the attorneys about what do you think? Because if we have jurors that are scared to death, and it really, you as attorneys need to be in on the decision about whether we bring those jurors in and decide your case or not. And so we're going to try to be sensitive as to that, and that type thing, just common sense.
Well, Judge, on behalf of all the federal practitioners in the Northern District, we greatly appreciate your leadership and the leadership of all the judges there, making reasonable accommodations, but at the same time, understanding that we need to move forward with cases. And so we appreciate all the extraordinary efforts and the undertakings of everyone. So, Lord,
and I'll say this. I would love to have any input that you all might have. My strong recommendation would be that the federal practice bar meet together and talk about the things that you and I have talked about, and maybe make recommendations themselves. I mean, I've heard everything from we're going to put screeners at the front door that are going to screen people.
Right.
Well, the problem with that is, the science that I read says a large majority of individuals that have coronavirus are asymptomatic. In other words, they're not going to have a fever. They're not going to show any signs of it.
Right.
And so what I'm afraid is by us putting people at the front door checking individuals, all we're doing is giving other people a false sense of security. And they might let their guard down thinking they're in a safe environment. I think that would be wrong.
Yeah.
We've got some courts in the country that are pushing to have medical tests done for everybody before they come in the building. One, extremely expensive to try to do that. And two, I couldn't imagine how you could get that done quick enough. And then, you test them and an hour later, they've already been exposed to something else if you didn't let them in the building. And so it's really not feasible to do that. I think the best case is to use common sense, social distance, wash your hands when you touch anything, and just assume that the virus is pretty much everywhere. And if you do that and you're careful, I think you'll be fine.
Chief Judge Coogler, again, thank you very much for your courtesy today and providing this update, and we appreciate it very much.